This video is made possible by Practical Defense Systems, the best online security training at the lowest prices. You can start your security career today online at pdsclasses.com. Check them out. Hi, this is Joel Persinger. I'm the Gun Guy. Thank you very much for all of your support on GunGuyTV and all the things that you do. I'm super grateful for all of that. I hope that you don't stop. There has been a lot going on lately with AR lowers and the Polymer 80 raid and all this other stuff. And there's a lot of information out there, but I'm afraid there's also a lot of misinformation out there. So I've asked Dan O'Kelly, who's a retired supervisory special agent from ATF, to come on the show again and give us the truth of the whole thing and clear away some of the nonsense that you're going to run into all over the internet so that we can actually figure out exactly what is ATF doing and what are we dealing with. Before we do that, I do want to remind you that one way to help GunGuyTV, if you'd like, that doesn't cost you a dime this Christmas, is you can do your shopping on Amazon through our Amazon link. The easiest way to do that would be go to our website at GunGuy.tv and look for the Amazon banner on the top. And if you click on that, it will take you to our Amazon page through our link. And if you bookmark that page, and every time you shop Amazon, you go back to that page before you start shopping, then we'll get credit for whatever you buy. It helps out GunGuyTV a ton. And yes, I know, before you put in the comments, Amazon is not firearms friendly. I get it. But guess what? Everybody shops Amazon anyway, so we might as well pick their pocket and help out GunGuyTV just a tad. All right, let's go talk to Dan, shall we? Well, Dan, can you give us the skinny on what exactly is happening with ATF and the whole AR pistol thing?
Okay. The biggest thing that has everybody riled up is the fact that ATF has published this general notice in the Federal Register. They filed it, published it, whatever word you want to use, December 18th, and public comments are open until January 4th. If you want to go on there and tell them what you think, not that it'll necessarily do much good. I think when they do these things, their mind is already made up, for what that's worth. But what they published is called a general notice. Now, that's within the law, and there's some legal stuff here. Not that I'm an attorney, but I've spoken to a couple of our staff attorneys and had clarification on this before I started speaking about it. This general notice that they filed, the reason they filed it, well, we'll get to that in a second. So here's where we start. After years of AR-15s and similar pistols being okay without braces, with or without braces, how did we end up all of a sudden with ATF saying, hey, we're going to change those things to short-barreled rifles or maybe any other weapons? And that's where this general notice comes in. So if you recall, back in June, 7 members of Congress wrote a letter to ATF and said, hey, ATF, you've been grumbling about this, AR pistols with braces being SBRs, and you've never actually laid it out what the parameters are that you use to determine which ones would be an SBR and which ones wouldn't. And that leaves us all in legal jeopardy, legal limbo. So we demand that you tell us in writing, what is it that you consider? What features that are different from one that you consider an SBR from one that you don't? So that letter held ATF's feet to the fire, and they had to put something in writing at that point. And what they put in writing is this general notice. They published it in the Federal Register, and these comments are still open until January 4th. Now, what seems so official about that is the fact that that's not what ATF usually does. What they've done for decades is put out these ruling letters, which are not really rulings. They call them rulings, but actually they're just opinions. Every time somebody sends a gun to them, sends a gadget to them, hey, ATF, what do you classify this as? ATF puts out one of these letters that they call a ruling letter. Everybody refers to them that way, when in fact, they're not. They're just opinions. They don't have the force and effect of law. Now, there are such things as ATF rulings, and every once in a while, ATF puts out an official ruling. When they do that, they have to publish in the Federal Register, similar to this thing we just talked about. But what they publish isn't called a general notice. It's called a notice of proposed rulemaking. I know this sounds like a bunch of legal garbage, but it's not a big deal. difference-wise. It's pretty clear-cut. If they want to change the law and make a new ruling that you actually have to go by, they publish one of these Notice of Proposed Rulemakings, or NPRM for short. There's 90 days for everybody to comment on. And then at the end of that, they change the law as they see fit. That's what they did with bump stocks when they went from not machine guns to machine guns. I agree with it or not, and I don't, because bump stocks are not full automatic. They're semi-automatic, just for the record. And I'll testify to that the first chance I get. But that's what they did. What they did here is not an NPRM, just a general notice. The only reason they published it is because of that letter from Congress. And, you know, for what it's going to be worth, we can talk about what did ATF say in that general notice. What they said, some of the things they said didn't make a lot of sense. You know, they listed the parameters that they use to determine which braced pistols they consider SBRs and which ones they don't. Some of the things they brought up actually have some merit. For instance, if you have a braced AR pistol and it has a pistol eye relief, a rifle eye relief, you know, a short eye relief scope on it, or some kind of an optic where you can only use it 6 inches from your face, you know, that's going to be damaging to you in court if they go after you, because how could you use that optic when you're holding the thing out at arm's length? If you've removed the Velcro strap from it, so you can't actually connect it to your forearm. There's a couple others, but the majority of what they said is sort of ridiculous. They talk about the, you know, making the brace a different length. And I have to laugh at that, because does everybody out there have the same size shoe? Of course not. Well, everybody out there doesn't have the same size forearm or forearm length either. So a 6'7" shooter, you know, versus a 4'7" shooter, you need different length braces to connect to your different size forearm. You know, but ATF just comes out and says, well, there's one length of forearm brace, and if yours is longer than that, then it's a stock. No, it's not. That's your opinion, ATF. And if we end up in court on it, then people who are familiar with this topic can testify just like you do, and the judge and jury will decide whether you're right or wrong. So these opinion letters of theirs are just that. They don't have the force of law. They're just opinions, but
they don't have the force of law, but they're treated that way.
Right.
And arrests are made based upon those opinions, or not made based upon those opinions. I agree with you. I think it sounds, oftentimes when they do this, their mind's already made up. So where does that leave us going forward if indeed their mind is already made up, and no matter what the public says, they rule according to where it appears they're going?
Well, here's the process as I've seen it through the decades. ATF's firearm technology branch, you know, there's a lot to the technology of firearms. A lot of people don't know what that technology is. You can learn it. I mean, we teach it. That's the reason our company exists. But for those who don't know it, ATF can come in and say, well, you know, this is that and that is this. And short of the training, the kind of training that we're trying to get across, people just have to go, okay, what ATF said. That's what jurors and judges usually do. You get into a firearm prosecution in court, and before long, the jury, the judge, they get confused. You know, I don't know what these people are talking about. So they default to, hey, whatever ATF said, I'm going to trust them, that they have the public's best interest at heart. And once they do that, the defendant is usually doomed to be convicted. However, when the defense attorney hires an expert who understands these things and who comes in and explains them to the judge and jury, the other side of the coin that ATF doesn't tell you, you know, then they see things like, well, wow, an AR-15 lower is not a firearm. It doesn't fit the definition, even though ATF's been saying it does for 48 years, which just happened last year. There are a number of these things. I could name a half a dozen other issues. You know, once it gets explained to the court, then they see the other side, and ATF doesn't get their way. However, because that doesn't happen often enough, ATF's been getting their way for decades, and they've sort of reached what I call this sacred cow status where nobody questions them. And then at some point, all they have to do is say something and it flies, whether it's right or wrong, because nobody digs into it, nobody challenges it. So I think that's, how we got where we are.
There is in a minute I want to talk about the issues with specific companies. I mean, they went after the honey badger thing. We talked about that the last time you were on, and then now that we got the Polymer 80 deal and some other things. But there is also out there, which we didn't chat about earlier, there's also out there now, I see on social media, Defund ATF. So I want to ask the question, because you were there for a long time, and now, if anything, you do battle with them in court on kind of a regular basis. Are there things that ATF does that are actually good for the country?
They do. They're a law enforcement agency, and, I'm afraid to say a percentage or say the majority of or what have you because of the controversy over ATF's existence. But a lot of the arrests they make are justified, and the people need to go to jail and did violate the law. So, yeah, I mean, I can't tell you the number of people that I've known in ATF that are just stellar, wonderful people. But as far as the agency, this whole defund ATF, get rid of the ATF, abolish the ATF, I have to chuckle. If you get rid of the ATF, do you think the gun laws are going to go away? Starting tomorrow morning, that it's going to be okay to saw the barrel off of your shotgun to 2 inches and nobody's going to say anything? The gun laws are still going to exist, and somebody's going to enforce them. So who do you think that's going to be? Well, if ATF doesn't exist anymore, guess who it's going to be? It's going to be the FBI, even if it's the DEA, some federal agency. And it's probably going to be the FBI, which is 5 times bigger than ATF, has 5 times the budget, if not 10 times. And you're going to wish ATF was still, the one out there doing this, because they're understaffed, underfunded. And, trust me, if you want to see some aggressive firearm enforcement, get rid of the ATF. It's going to step up multiple times. So defund the ATF, what does that do? You may want to get rid of the gun laws. You may want to repeal the NFA. Now that, might have some merit, but you're not going to get rid of the gun law of the prosecution of firearm violations.
What is the whole shtick here with the Polymer 80 raid? Do you have any insight into that?
There are 4 definitions of a firearm under the Gun Control Act. The first one is the one everybody knows. Any weapon which expels a projectile by the action of an explosive, and there's verbiage in that definition that says, may readily be converted. It says a weapon which may readily be converted. Well, on one hand, readily may be converted. That covers a lot of ground. That's completely subjective. What I think is readily, if it takes a week to convert something to a shootable status, whereas ATF can say, well, if you can do it within a day, you can do this within 2 hours. I've seen one thing written where some guy did a Polymer 80 Glock type pistol in 20 minutes. So that's readily convertible. Well, then again, one guy, is also a trained machinist and has a garage full of machine tools, and the other guy's got a file and a drill and has no idea what he's doing. So because of that, may readily be converted, ATF says, okay, these companies that are selling an unfinished lower, a slide, a barreled up or whatever, depending on the model, the whole parts kit, and all you have to do is finish the lower, that is a weapon which may readily be converted, and it's therefore a firearm. So since it was manufactured by somebody in numbers and they're not a licensed manufacturer, then it was manufactured in violation of the law, i.e. Manufacturing without a license. So it's the fruit of a crime, and every one of them is contraband, which we have the authority to go seize. So they're going around everybody's houses and, telling them we have the right to take this from you. So where is it? If you don't give it to us, we're going to get a search warrant, come back and, take it from you anyway. There are a number of points I could comment on there, but let me leave you with this. I am waiting for the chance to testify in court on one of these, because what that definition says is a weapon which may be readily converted. How is a pile of parts a weapon? One of the legal things I'm waiting to argue is there are some firearms out there. Picture a Hammerly or a Walther 22 single shot, to use an extreme example, Olympic pistol. Was that designed as a weapon? No, that was designed as something for target shooting. So it doesn't satisfy the definition of a firearm. It's not a weapon. It does expel a projectile using the action of an explosive, but element 1 is missing, and element 1 is missing from that definition concerning these Polymer 80 kits too. So that's a little deep, but ATF does not have the authority to take these from you without a warrant. They're not going to get a search warrant for your home. If they had the probable cause to get a search warrant, they'd have shown.
They wouldn't be doing the knock and talk in the first place, right? Right. They wouldn't knock on the talk and say, "Hey, we're going to take this. Come, give it to me." If they could actually get a warrant, they would have done that. Right. It's
like these cease and desist letters. If you're already doing something illegal and they give you a C and D letter, it's like, why aren't you here to arrest me if it's illegal? So in other words, I've already committed a crime, but you're telling me it's okay if I just don't do it again.
My understanding of a search warrant, maybe you can help me with this. And I know you're not an attorney, but you're 30 years in law enforcement. My understanding of a search warrant is that there are certain components that are required, one of which is that you have to name the specific item or whatever it is you're searching for to seize. And the other is that you have to have some probable cause to believe that that item is actually in that physical location when you go there. Am I correct in that?
Correct. It has to be, the fruit of a crime has to be there. The information has to be fresh as determined by a judge. And, if these kits are not a firearm, they're not the fruit of a crime, for starters. And unless I missed something, I haven't seen the recent court decision where a judge said, I consider these kits to be a firearm. So therefore, how is ATF this is one of those ATF opinions that they're treating as a ruling when actually it's just an opinion.
Well, I mean, even so, even if a judge did come out and say these things are illegal, what do they got? They got let's say I purchased one, which I didn't, but let's say I did. They've got my name on a list of customers. Does that tell them that the item that they want to seize is actually in my home?
Well, what they're going to say in the affidavit for the search warrant is, Joel Persinger, we know he purchased this thing. He lives at 123 Main Street, and it's commonly known that people keep firearms in their home, that they keep them long-term. And so we have probable cause to believe he is now in possession of a firearm, which is the fruit of a crime. That's the way the affidavit's basically going to be worded. A lot of that is supposition.
Most.
But again,
yeah, it is. I get it.
Judges trust them to be operating in good faith, and therefore they approve these warrants. When they get to your house to do this interview, if you've already sold it, I bought it as a gift, I sold it, I gave it away, who'd you sell it to, who'd you give it to? None of your business.
It's not a firearm. There's no requirement for a bill of sale in a state that requires that. There's no requirement in a state that requires it go through an FFL. It's not a firearm. And which brings up another subject. You testified years ago. We've talked about it on this show half a dozen times if we've done it once. You testified in court and got a judge to agree with you that an AR receiver, an AR lower, is not a receiver.
Correct.
And it's not a firearm. How does that play into this issue? Considering these things are essentially unfinished lowers, which a judge has already agreed with you is not a receiver in the first place.
Well, that's one of the points I was hoping to be able to make. This whole idea of firearm classification is something that any individual can do. ATF acts as though Firearm Tech Branch does firearm classifications, and you have to trust what they say. Anybody can classify something as to whether it's a firearm or not if they have a reasonable command of the English language. You go to the definitions, they're on the internet for anybody, and the definition of a firearm Any weapon which expels action of an explosive. Number 2, the frame or receiver of a firearm is a firearm. So you go, well, hey, is this a frame or receiver? What's a frame or receiver? Well, that definition is also in federal law. So you go to that definition, and that definition says a frame or receiver is that, quote, part, meaning singular part, which houses the hammer, comma, the bolt or breech block, comma, because every gun has one or the other, not both, the firing mechanism, comma, and is usually threaded at its forward portion to receive the barrel. So you go, well, I'm holding this thing in my hand. It's an AR lower. ATF says this is a firearm. It does house the hammer, check. It does not house a bolt or a breech block. That's not here. It does house a firing mechanism, and it is not threaded to receive the barrel in any way, threaded or pressed in or any way. So that's 2 out of 4 elements. I'm sorry, but this isn't a receiver. Therefore, it's not a firearm under that definition too. And for 48 years, ATF's been doing that. You know, anybody could have called them on this since 1971 when they started doing it. But I ended up being the lucky one to
and thank you
tell that to an attorney when he asked. And,
yeah.
And it doesn't just apply to AR lowers. You know, for instance, a Glock frame lower, I want to stay away from the word receiver. A Glock lower, even when you complete it, it's 100% finished right out of the Glock factory. It has one of those 4 elements, 25%. It's not a firearm by itself.
Well, and if we go back to the ARs, if the AR, a finished lower, if a completely finished lower, ready to be built into a firearm, if a completely finished lower only has 2 of the 4 required elements. It sounds, the way you read it off, it sounds like it must have this and this and this and this, not this or. If it only has 2 of the required elements, how then does a quote-unquote 80% or unfinished receiver have any of them? And
well,
it wouldn't be a receiver. It's just a block of metal.
You're correct. And it does say the word "and" twice in the definition.
Okay.
If you go read the definition, the word "and" is in there twice. It's not one or the other. It's all of them. So an 80% lower is not a firearm because it's not a receiver.
Well, because 100% lower is not a firearm.
Well, that's the funny thing. You have 2 huge civil suits were just filed within the last 30 days, give or take. One out of California, one out of Syracuse, New York. They're both against ATF. They're suing ATF saying, hey, because you have not ruled, or whatever verbiage they're using, Mr. ATF, because you have not ruled that 80% lowers are firearms, people are making all these ghost guns and people are getting killed in the streets, and therefore this blood is on your hands. And, you know, I'm reading this, scratching my head and sort of chuckling, and I'm going, can't wait to get brought into one of these civil suits as a witness and point out to the plaintiffs that it's already been proven by a federal judge that a 100% AR-15 lower is not a firearm. So good luck proving that an 80%er is a firearm. Not going to happen.
Now, how many years ago did you get that judge to agree with you? I mean, it's been what, 5-6 years ago, hasn't it?
The first time I testified to it was in 2014. That was in the Aries Armor case in San Diego. Then there was the U.S. versus Jimenez case. Jimenez, sorry, my Spanish, I don't speak it. In Oakland, California in 2015. That case had Attorney General Loretta Lynch write a letter to Speaker of the House Paul Ryan and tell him, hey, this is screwed up. You need to have ATF fix this. ATF never did anything. Then in 2018 was Joseph Roe, U.S. versus Roe, in Orange County, California. And the government cut a sweetheart deal with Mr. Roe after I testified to this, because the judge put in writing that, hey, I agree that AR lowers are not a receiver based on O'Kelly's testimony. And so the prosecution, the U.S. Attorney's Office said, look, Mr. Roe, we're going to give you a deal. If you plead guilty to manufacturing without a license because of the complete AR rifles that you did complete and sell on occasional days, if you plead guilty to that, you'll be found guilty of a felony. 1 year later, we will completely expunge and get rid of this whole thing, and you'll be clean again. You'll be non-felon. It'll just go away. But by you pleading guilty, this judge's planned, epiphany that AR lowers are not a firearm will never make the light of day. So he took the deal rather than throw the dice and end up in prison. That was in 2018. And then, to answer your question, 2019, I testified in Toledo in the Rowald and Robeson case, and Judge Carr agreed that ATF was way out of line, that AR lowers are not receivers and they're therefore not firearms. He dismissed the charges, and in April of 2020, ATF finally gave in and said, okay, we're rewriting the definition. It's going to take 2 to 5 years. Which is sort of funny because
takes 2 to 5 minutes. It's not it's not hard,
right? Well, the heck of it is, just a month before Judge Carr made that decision, a guy in Oklahoma got sentenced to 7 years in federal prison for being in possession of an AR lower and some high capacity magazines. He didn't have anything shootable. If ATF had done this when they should have, the guy would have never gone to prison. Of course, that man's lawyer has filed an appeal since, and I'm sure he's out by now or should be soon. Not that that gives him back the time he will have served, but you can only wonder how many other people are in prison or have done time in prison for something that wasn't even illegal for 48 years.
Just about everything about this is troubling, but I think the thing that troubles me most is the fact that even if I want to give a lot of grace to ATF and say they were woefully ignorant, they haven't been woefully ignorant since the first time you testified on this in 2014. That's 6 years ago. And they're not woefully ignorant now. So if they're looking at Polymer 80 or any other quote-unquote 80% lower partial piece of metal that you can make into a lower, and they're saying that those are illegal because they're firearms, they already know better. So what does the average citizen do other than refuse to answer the door or say, I don't want to answer any questions or whatever? I mean, how do we is there a way to finally get ATF to stop abusing this issue?
Well, ATF has already admitted that they are rewriting the definition. And since that information came out, they have admitted, hey, the present definition doesn't work. So between now and the time the new definition takes effect, 2 to 5 years down the road, there's pretty much an open season on AR lowers, thanks to them, and the models of all the other guns that we haven't even talked about that don't qualify. The U.S. Attorney's Office has, I don't have this in writing because a lot of this, they don't put it in writing because then when you do, you can hold up a copy of it. But the U.S. Attorney's Office, and I have this on good counsel, has already put out the word, we're not prosecuting any more possession or manufacturing of an AR lower or one of these other models. So it's, in effect, not illegal to, for people who are prohibited from possessing a firearm, from possessing any one of these lowers from any of the models we're talking about. It's also, in effect, not illegal right now to make them hand over fist without a license, because even when you do, you're not manufacturing firearms, you're manufacturing nothings. And it doesn't take a federal license to manufacture nothings.
Well, this is one of the things they went after Polymer, the whole Polymer 80 thing was the idea that they were manufacturing firearms without a license. Isn't that correct?
Right. And when this finally goes to court, if it does, who knows how long that'll take. But when the first federal judge renders his opinion on it and says, you know what, these things are not readily convertible, so they are not firearms. Well, then all the ones they took from people, just you're out of luck. Somebody, sucks to be you because somebody took your property and it wasn't illegal. So sad situation. Again, there needs to be a regulatory agency so that things don't go off in left field, but a regulatory agency should not be anti the commodity that they're regulating.
This is one of the problems that we have in addition to that, just with regulatory agencies to begin with. The way our Constitution is written and structured, laws are passed only by the legislature and signed into law by the president, if they're federal laws. And then they are enforced by the executive branch. But as far as I know, nowhere in the Constitution is there the idea that a regulatory agency can usurp that lawmaking power in the form of making a regulation. But it happens all the time. The federal government makes regulations and they are enforced as if they have the force of law. But under our Constitution, they don't. They're just a regulation. At some point or other, as people, we have to stand up to that, because otherwise bureaucrats just make regulations like crazy, like what you're talking about with ATF. They have some bureaucrat somewhere in ATF has essentially decided that these are illegal when they're not. And if we actually look at the law itself, they're not illegal, but they're not interested in ATF. They're not interested in what the law says. They're interested in what their regulation says or what their letter of opinion says. And we, the people, have to abide by that. I think that's the biggest problem I have with this kind of stuff. And I think that's where I hear a lot of people angry about it, because it is essentially an abuse of power. Am I reading this wrong?
No, you're not. To clarify a little bit, there are rules, there are regulations, and there are opinions. Rules are things that have been published in the Federal Register. They went 90 days for public comment, and then ATF or whoever the regulating agency is put it into law. So an actual ruling, like ATF ruling 2011-4 concerning carbine kits along with pistols like the Thompson Center Contender or what have you, I could name a few others. Those do have the force and effect of law. Regulations have the force and effect of law. For instance, the definition of a firearm frame or receiver is found in Chapter 27 of the Code of Federal Regulations. That definition is law. But these opinions that ATF comes out with, that if you put a vertical foregrip on your pistol, that's in any other weapon, or whatever else, those are opinions. Until they go through the efforts to publish an NPRM, wait the 90 days, and actually turn it into a ruling, all they do in a lot of situations is call it a ruling. And it's not a ruling, it's just an opinion. They like to throw that word ruling around as though all they have to do is write something on a piece of paper and it counts as a ruling. Afraid not, ATF. You have to go through the NPRM 90-day thing. Then it's a ruling and it has force of law. Until then, it's merely your opinion, and you hope when you get to court, the judge or jury is going to side with you.
Or for that matter, you hope when you knock on the door that the citizen's going to be ignorant of it and comply with you.
Correct.
Which obviously we're trying to solve that here. Have they sent out, seems to me there was a letter or alert or something that was sent out. I think you and I talked about it before with regard to some of this stuff. Can you talk about that?
An alert, who are we talking about? The Wiley Law Firm Client Alert?
Yes, thank you. I couldn't come up with it. Yes, thank you.
Yeah, well, ATF, and I don't know how Wiley came, I can surmise that ATF probably gave some of these opinion letters to industry people, gun manufacturers, whomever, saying, you're trying to import braced pistols, and we're not likely to approve that because we consider braced pistols to be any other weapons. Wiley is probably, and again, this is just a guess, I don't have this confirmed, the attorney for one or more of those industry people or companies. And after having heard that from their clients, Wiley probably dug into this, got a hold of ATF, and then put out this article that we talked about last time called the Client Alert, the Wiley Law Firm Client Alert, where they said, hey, ATF is talking about making braced pistols AOWs, so they can't be imported because only sporting guns can be imported. Another whole issue we could talk about, but we won't right now. So as a result of that, everybody started getting up in arms, And that's what I commented on in our last interview, where I said, hey, you look at the definitions, AR pistols, even without a brace, they're two-handed guns. They all have a forward grip, whether it's horizontal, angled, vertical, whatever. And a two-gripped gun, a two-handed gun, isn't any other weapon. If you look at the definitions, we already talked about that. We won't go into it again. So, whether it's imported or whether it's American made, a two-handed gun is not a pistol. It's not a handgun. Therefore, it is an AOW. So ATF calling these braced ones SBRs versus AOWs, the result is the same. If they win, it's an unregistered NFA firearm. Whether you get charged with possession of an unregistered AOW or unregistered SBR, it's still a violation of 26 USC 5861. Same law, same prison. Doesn't make a big difference which NFA category it falls into. But again, I may have gotten off topic.
I don't think so. And thank you for coming up with Wiley. It's word retrieval problems. I couldn't come up with it, and I hadn't written it down. I couldn't come up with a name. It seems to me, because of what you said earlier, that a lot of this with the unfinished lowers was precipitated by political pressure. That's kind of what it sounds like. And I guess my question would be how susceptible is the ATF to political pressure? I mean, does political pressure drive them to enforce or not enforce certain things in certain ways?
Yes. For instance, the bump stock thing, that was because President Trump came out and said, hey, bump stocks are gone. I've already told the NRA, I've told whoever, that was pretty close to his quote. He decided he didn't like bump stocks, and he made a call, and you know what, find a way. So then it was up to them to figure out which way they wanted to do it. But that was due to political pressure. You can go back to 1994 when the street sweeper and the USAS 12 all of a sudden overnight became destructive devices. No other similar shotgun since in 25 years has been considered a DD. But all of a sudden, we don't like these. That was because a high-ranking politician took a tour through ATF, and one of each of these was laying on a table, and he goes, what are those? And the firearm enforcement officer says, well, those are shotguns, sir. And the politician said, what, are you kidding? Like for duck hunting? Those aren't illegal? Well, no, they're just shotguns. As long as they're sporting, they're not illegal. So he made a call later that day from Capitol Hill and said, hey, ATF, I expect you're going to do something about this. So yes, sir, 3 bags full. They made USAS 12s and street sweepers destructive devices. Political pressure. ATF, what I was going to say a minute ago and got sidetracked, the guys in firearm tech branch, they are so busy, trust me, they don't have time to pay attention when it comes to trying to think of new things to make it illegal. I can tell you they don't do that. It's all they can do to keep up with what they're told to do, because they have to assist law enforcement nationwide, whether it's ATF or some little police department. They have to service the whole gun industry nationwide, et cetera, et cetera. And there were 8 of them. That's where I got off track. There used to be 8 of them from 1988 when I came on until earlier this year. 8 people trying to cover that whole job. So they don't have time to make up anti-gun laws.
I keep thinking about the average citizen now getting arrested for this and has to wait until it works its way through court. And you talked about the guy sitting in prison right now over something that really isn't illegal. Perhaps there's a quicker way. If people is there value to the people contacting their congressman and raising a bunch of stink about this? Is there value to contacting their senator, raising a big bunch of stink about that? Is there value to peacefully showing up at the Capitol and having a rally out in front of the Capitol about it and making enough noise that maybe some of these federal representatives actually pick up the phone, call ATF, and say, what the heck are you doing?
I really think there is. I think, you can see that these 7 congressmen who wrote the letter to ATF in June saying, hey, what are you doing with these braced AR pistols? We want something in writing. we're tired of just hearing your daily whims as to what you're going to do. And it got traction. On the other hand, you have pro-gun and anti-gun politicians. If the politicians in your area, your congressmen, your representatives, your governor, whoever, if they're anti-gun, good luck, because their mind's already made up. So you have to have the people on your side be on your side, for starters.
Well, and a lot of people in the country do. I mean, I'm in California, where both of my senators, one of them's trying to be vice president, and she's a kook, and the other one's Dianne Feinstein, who it may not be a kook, but she's ardently anti-gun and getting to the point where she's getting a little feeble because she's older. I'm not going to pick on her about that, because it's going to happen to me too, so if I live long enough. But neither of them are going to help. We do have some House members who might help, but those are, I don't know. Mine won't, certainly. But if you're in other states, Arizona, Texas, whatever, you're in states where you can actually make some noise, it might not be a bad idea to go do so. I would urge you, if you're watching this, to do that. I'm only going to urge you to do it peacefully, please. That would be my one suggestion.
Well, the one other thing I would add on that note, Joel, is in addition to contacting your representatives or your congressman or whoever, is learn the definitions. Become familiar with what these laws say. For the definition of a pistol, the definition of a rifle, the definition of a firearm in general, the definition of a machine gun. Learn them, and then when you see something, and you have to be realistic. You can't try to make it be what you want it to be. It is what it is. Does it have, how many elements are in this definition? 1, 2, 3, or 4? And does it have them? And if it doesn't, and yet ATF's calling it X, they're wrong in their classification. The way you learn those things is to learn what we teach, because, that's what we teach. How to know what the definitions are. I tell all our students, learning the definitions, you're 75% of the way there to becoming a firearm expert, because that's what it's all based on. After that, everything else just falls into place. But learning the definitions, what the laws basically say, the regulations, allows anybody to see whether ATF is off the reservation on a certain issue or not.
How beneficial is it? Let's say I take the class and I learn the definition, and then I contact my Congress member or my senator because I know that they're pro-Second Amendment, and I'm not going to speak to the Congress member or the senator. I'm going to speak to a volunteer or a member of their staff. I'm assuming that member of the staff is likely not to know the definition. In fact, I'm going to say probably a 99% chance that they're not going to. You're shaking your head. Okay, so that being the case, how valuable is it for me in that conversation or in that email or in that letter to provide the definition to them? Does that add any weight to my opinion?
Yes, you have to take that first step, though. Look at how long it took for me to get traction telling federal judges that an AR lower is not a firearm. Through 4 different cases, all in federal court. We're not talking about, Johnson County Court in some state. We're talking about federal courts with federal judges. It took 4 trials of me saying, look, here's the definition of a receiver. This thing in an AR-15 only has 2 of them, so it doesn't qualify. That's pretty cut and dry, pretty plain and simple. And it took until the 3rd and 4th ones for me to get an agreement and then an actual judgment to get this procedure stopped. So telling your, administrative assistant or whoever is in that governor's office, hey, here's what I found, just start building your traction.
What do you see as the likelihood of ATF actually going and knocking on doors to collect these things?
Not likely. What they've said in this general notice is that, hey, there are some parameters we use to consider one an SBR. Again, 2 or 3 of them have merit, having a rifle relief scope, no Velcro strap, making the thing 3 feet long where you can't even connect it to your forearm. You're shooting yourself in the foot if you're doing some of those, because what are you going to use as a defense in court. On the other hand, the rest of them are subjective and can go either way. At the end of the day, what's missing from this general notice is the fact that ATF doesn't say if you have 3 or more of these, then it's an SBR. If you have 2 or fewer, it's not. They don't tell you how many you need to have before they're going to consider your gun an SBR. But if you stop and remember that in 2012, they said braces are okay, although then they said you can even shoot them from the shoulder. They reversed, themselves because originally they said you can't.
Yeah, I remember that.
Then they wrote and said, no, you can't shoot them from the shoulder. That would be an SBR. Then the 2017 letter saying they tried to clear the air and ended up muddying the waters even more by saying, having it go against your shoulder during shooting is not by itself a violation. What they were trying to say is it's all about intent. And they couldn't come out and give the actual example, but what I saw as the actual example was this. Let's say you hold your buffer tube up against your cheek as a cheek weld and you're firing a rapid multi-shot string. If during that multi-shot string, the recoil should make the brace go against your shoulder for a second, that doesn't make you a felon because there was no intent. What they were saying in that 2017 letter is it's still about intent. Are you trying to skirt the law? Right or wrong? Most people went out in the gun press and said, hey, ATF just reversed themselves again and said, shooting it against your shoulder is okay. No, that's not what they said. And the bottom line is they're still not saying all braced pistols are a problem. They're saying braced pistols like this and like this and like this, et cetera, are a problem. Granted, some of the things they're citing are ridiculous. Some of them have a lot of merit, but at the end of the day, they don't tell you which ones they're going to use or how many. So, but I don't see them saying, hey, they're all illegal. They have not said that. They're liable to come out and say, hey, they're all AOWs because of the 2 grips, at which point, like I said last time, take your forend off of it and it's back to being a 1-grip gun. It's a handgun. And there's no problem. It's not an AOW.
Are you of the opinion that this is part of some master plan, or is this something that has happened sort of because of political stuff?
I fully believe that plan exists. I don't believe it's an ATF plan. I don't believe ATF has that plan. I believe that your Dianne Feinsteins and people of her ilk, their idea of happiness is the last gun in America being confiscated.
Well, she said so. Mr. and Mrs. America, turn them all in.
Right.
So,
your, what's his name? The other guy that was running for president who says, hey, I'm coming to get your AR-15s.
Beto O'Rourke or whatever his name was. Beto, whatever his name is today.
There are people out there who fully intend to do that. Are they going to have success? That depends on what state you're in. Who ends up being president, which I don't think is a done deal yet. But
no,
regardless,
I don't either. And I know who I want to be president, but that's a different show.
Right, and it depends on what Congress does. Even if when it gets to Congress, is Congress going to approve it or not? I see it becoming a lot more difficult for gun owners in the future because of obvious reasons.
Yeah. Do you think ATF gets used as a tool in these things?
Well, certainly, yeah. I mean, the history of ATF was tax collecting, explosives, firearms, alcohol, tobacco, that was all excise tax stuff. Collect the tax. That's why they were, so hot and heavy over still busters. They were the still busters back in Prohibition. Not because necessarily you were anti-alcohol, but because people who were running stills weren't paying the federal excise tax on the liquor, and the government was getting gypped as they saw it out of that tax money. So, it was explained to me a long time ago that ATF was basically the dumping grounds, and it wasn't ATF then, it was a division of the IRS. but they were given all the laws that the FBI didn't want. Go bust people for not paying taxes on tobacco, alcohol, explosives, for not paying the tax you have to pay on a machine gun or a short-barreled rifle or a silencer or what have you. So, ATF is a tool to do that.
Well, I mean, really, and without getting too deep into the weeds here, the whole issue of the Polymer 80 thing and the and the AR pistols does revolve around they're not getting paid the tax for the SBR or the tax for the any other weapon, or we're gypping in their minds, we're gypping the federal government out of their money, which they shouldn't be getting anyway. But that's a whole different conversation. Is there anything we haven't covered that we should have covered? We've been on for quite a while, so I want to make sure I'm not dragging you out too long.
I just wanted to say there are some other points that I've written a couple of articles, one about the history of this AR lower thing and where that's come to today. And then I've written an article about what we've talked about today. Maybe I didn't hit every little issue, but those are both going to be posted on my company's Facebook page, gunlearn.com. Or there's another one, International Firearms Specialist Academy. Both are.
Can I post those in the description of the video, Dan?
If you post my articles? Sure.
Yes, if you send me those links, may I post them in the... Okay, so what I'll do for you is I'll post those in the description of the article so you find them down in the description so you can go directly to them. You don't have to hunt for them. I'll also put Dan's website in there, so if you want to take the classes, and I strongly suggest you do so, you'll be able to do that. And I think you've got some online classes, don't you? People don't have to travel to take them necessarily, do they?
Right. Our course, which teaches the full comprehensive gamut of firearms and firearms and ammunition technology, is called the Certified Firearms Specialist course. We teach it as a live seminar. It's 3 days long, and then you get as many weeks or months as you need to complete the tests. You can take it online also. Pay for one module at a time, pay for them all at once. We also send out to you a 366-page study guide to take your time, because some people start this not knowing one end of the gun from the other. Some people come into it with a pretty good handle on the firearm field. So not everybody starts from the same level, and we make it so it's easy for you no matter what level you begin at. But yes, please look into our training, because it's your best defense against being caught up in some of these messes that we've talked about.
Well, I will make sure that I put those links in the description for you so that you can check those out. The articles would be very important for you to read for certain. And if you have the ability and the time and the money and so on, I would strongly suggest that you take the classes. And my other urge to you would be active. I would like to see you be more active politically, which means make some noise. But as Dan alluded to, because he's been in this fight for a long, long time, we have to make noise the right way. Otherwise, we get dismissed as kooks or nuts or whatever. We may not like that fact, but it's like I said, I don't live in a fantasy world. I live in a real world where I have to operate. And unfortunately for you, you do too. So let's see if we can fight effectively rather than ineffectively. That would be helpful as well. Is there anything I didn't cover, Dan, that we should cover?
No. Last thing I would ask is that people do give us a like on Facebook so they can keep track of what we post. That's about the only thing we use to keep the word out there, because we have a small staff and we don't use a lot of other social media. But no, I think we've done justice to the issue.
Thank you very much, my friend, for coming on the show. I know it's right before Christmas and you'd rather be with family, so I really do appreciate it.
Thank you, Joel.
My pleasure.
Merry Christmas.
You too. Have a great Christmas. And if I don't talk to you beforehand, have a wonderful New Year, and thank you again.
Thanks.
Thank you very much for staying with me as long as you did. I'm very grateful. I know these interviews can go kind of long, and as a result, they can seem a little tedious, but this information is very important for you to have. We've got to be able to fight this battle effectively, and in order to do that, knowledge is a very powerful thing to have. So with that in mind, I do want to urge you to check out those links. They'll be in the description, so you can check out Dan's page and also check out the articles that he's written on these subjects. They might enlighten you further than this interview has already done. Have a wonderful week, have a wonderful Christmas, and a terrific New Year, and wherever you go, whatever you do, be safe.